Confidentiality is a cornerstone of ethical healthcare practice and a legal obligation across the UK, Europe, and Canada. It fosters trust between patients and healthcare professionals, protects sensitive health information, and ensures that private matters are respected, even beyond a patient's death. This module explores the multidimensional nature of confidentiality, from day-to-day clinical interactions to complex administrative and digital data systems. 1. What is confidentiality in healthcare? Confidentiality refers to the obligation to keep a patient's personal and medical information private unless they provide explicit permission to share it, or there is a legally justified reason to disclose it. Confidentiality applies to verbal discussions, written documentation, electronic records, imaging results, billing and insurance data, observations made by healthcare professionals. The duty of confidence is part of the implied contract between healthcare professionals and patients, and it underpins professional codes of conduct, including those from the General Medical Council, GMC, Nursing and Midwifery Council, NMC, and the World Medical Association, WMA. 2. Ethical foundations of confidentiality. Ethically, confidentiality is grounded in respect for patient autonomy. Individuals have the right to control personal information. Trust. Without assurance of privacy, patients may withhold important details, which can undermine care. Non-maleficence. Inappropriate disclosure may cause harm, psychological, social, or financial. Fidelity. Healthcare professionals must honor their commitments to protect patients' interests. 3. Legal foundations and regulatory standards. Confidentiality is not just an ethical responsibility, it is a legal one. Legal frameworks: UK Data Protection Act 2018, Human Rights Act 1998, NHS Confidentiality Code of Practice, EU, General Data Protection Regulation, GDPR, Charter of Fundamental Rights Canada, Personal Information Protection and Electronic Documents Act PIPEDA, Provincial Health Information Acts, e.g., PHIPA in Ontario. These laws require data minimization, collect only what's necessary, lawful basis for data processing, e.g., consent, public health, legal obligation, clear documentation of access and sharing, right to access, correct, and delete personal data. 4. Practical applications of confidentiality. Confidentiality must be observed across all areas of care: clinical settings, maintain privacy during consultations, use private rooms, avoid hallway discussions. Administrative processes, secure filing systems, proper disposal of records, password-protected digital files, digital health tools, secure servers, encrypted communications, multi-factor authentication for EHRs, remote work/telehealth, confidential surroundings, verified patient identity, protected video platforms. Even non-clinical staff, e.g., cleaners, receptionists, IT personnel, must be trained in confidentiality procedures. 5. When can confidentiality be lawfully breached? Although confidentiality is a core principle, there are justified exceptions. With patient consent, when required by law, court orders, reporting child abuse, communicable disease control, public interest exceptions, preventing serious harm, reporting a crime or threat. Deceased patients, confidentiality often continues posthumously unless legally or ethically justified. Professionals must document what was disclosed, why it was necessary, who was informed, whether patient consent was obtained or not. 6. GDPR and confidentiality. GDPR requires that healthcare organizations ensure data protection by design and default limit access to patient information to only those who need to know. Provide patients with clear information on how their data will be used. Appoint a data protection officer, DPO, if they process large volumes of sensitive health data. Document all data processing activities. Article 30 of GDPR. Consent under GDPR must be Freely given, specific, informed, explicit for special category data, for example, health. 7. Case-based ethical dilemmas. A teenager confides about suicidal thoughts but refuses disclosure to parents. Dilemma: respect confidentiality versus duty to prevent harm. A patient with HIV refuses to inform their sexual partner. Dilemma: respect privacy versus protect third parties. An unconscious patient arrives with no ID. Dilemma: treat while gathering identity versus ensure informed consent and correct data assignment. These cases demand careful use of professional judgment, ethical reasoning, and legal consultation. Accreditation alignment. This module aligns with GDPR Articles 5, 6, and 9, CPD certification standards for ethics and data protection training, Health Information Acts, Canada, WMA International Code of Medical Ethics, 2022 update, GMC and NMC confidentiality codes. Accrediting bodies look for integration of local/international law, professional code alignment, scenario-based ethical reasoning, emphasis on digital privacy and EHR use.